shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. We currently have 5 hours of requested argument time. So please understand that the court is fully familiar with your cases, the briefs, the record, usually more than you wish we were. And so please keep your requests to the time you need, not the time that you want, so that I don't have to cut the time for you. And as I tell everyone, the light is for you, not for the court. So if my colleagues have additional questions because your argument has been so brilliant, I will let it go. All right? Okay, People versus Orlando Correra. Submit. Amtrust North America versus Insurance Specialty.
Good afternoon, Your Honor. On behalf of Appellant, I request 7 and 3, please.
Okay?
Respondent 10, Your Honor.
6 and 2 and 7. M. Darrell versus Shaniqua D. is submit. People v. Carlos Guzman. Submit. People v. Luis Sastre is a submit. Gomez versus Thomas.
Good afternoon, Your Honor.
Good afternoon.
I'm here for the respondent. We are comfortable submitting without the presence of the...
Wonderful, thank you. Please have a seat until the rest of the call of the calendar. Thank you. JN, an infant versus Strong.
Appellant 5 and 2.
Okay,
Good afternoon, Your Honor. Respondent 4 minutes.
5 and 2 and 4. People versus Kenneth Ferguson.
Good afternoon. Appellant request 3 and 1.
Okay,
Good afternoon, Your Honor. People request 5 minutes.
3 and 1 and 4. People versus Jatian Braxton. Submit. Lopez versus Rodriguez. Submit. State of New York versus Tyrone N.
Good afternoon, Your Honor. Your request 8.
Okay?
8 minutes, Your Honor.
All right, let's do 6 and 2 and 7. People v. Elijah Santiago. Submit. Nunes versus Turo, Inc.
Good afternoon. The respondent requests 3 minutes.
Okay, I'll give you 3 minutes. People versus Sterling Wade. Submit. People versus Andres Seda. Andres Seda. Submit. People versus Liz Thompson. Submit. Metropolitan Property versus Pentair Residential.
Your Honor, Appellant request 8 and 2.
6 and 1 and 6. Charlton versus 92 Pinehurst Avenue is a submit. Arc 292 versus Archdiocese of New York. Submit. They requested argument time and then they don't show. No problem. First case on the calendar, Amtrust North America versus Insurance Specialty. You may proceed.
Good afternoon, Your Honors. Daniel Sullivan, Howell, Schuster, and Goldberg for the Appellant Amtrust. We have 2 doctrines at issue in this appeal related to the partial dismissal on statute of limitations grounds. I want to try to simplify things and go right to the equitable estoppel issue, which if the court agrees with us on that issue, it will resolve the appeal. Equitable estoppel rests on the fundamental principle of equity, that you don't allow parties to benefit from their own wrongdoing, and it works.
Counsel, is your equitable estoppel argument undercut by the fact that the MPA allowed you to audit the defendant and also do on-site visits of the defendant?
No, Your Honor, it's not. So the first question is whether or is how the equitable estoppel doctrine works, right? Which is sort of part 1.
Well, equity,
I don't
equity
think that was
plays a-
his question.
Yeah. Thank you.
No. So I think the question you're asking is, do we need to show that the concealment prevented us from bringing suit? There is no case.
No, the question is, you had a duty, you had a right under the contract to go in and look for yourself. So your failure to do so, is that fatal to your claim? I believe is my colleague's question.
And the answer, Your Honor, is no. And the reason it's no is for two reasons. One, we did have informational rights and rights to obtain documents under the contract. We actually have a separate breach of contract claim, which is not at issue on this appeal, that says that they have failed to do that. So I think it would be improper to say that that existence of that right, which we say they did not respect, vitiates the equitable estoppel argument. More importantly, there is no case they have
I
cited.
know that toward the end of, as you neared litigation, there was a request for documents. Was there a request for documents prior to that in all the time that this contract was in effect? And they weren't providing documents and you sat and did nothing until now?
Well, so there's discovery's ongoing, and there's actually relevant information.
You
in the
know what
record,
I'm saying,
but I don't want
right?
to. Right. So the complaint doesn't plead that there was a request. It doesn't plead anything about the facts on that. But the case, Your Honor, there's no case that says you are on inquiry notice simply by virtue of having informational rights. What the cases that they cite show is that where the plaintiff had actual evidence of the wrongdoing or that there probably was wrongdoing, then you're on inquiry notice and have an
So
obligation.
there's no due diligence requirement on the part of your client?
That's correct, Your Honor.
Okay.
And there's no
Counsel-
case that says so.
Counsel, did you request documents in 2022?
We requested documents, I believe, at either the end of 2022 or 2023. I'm blanking on the exact year. And our argument is that they failed to do so until after the litigation actually started. But the question that, the prior question is what happens where, as here, the fiduciary, because nobody disputes that ISG was a fiduciary, right? So if the fiduciary conceals the wrongdoing, equitable estoppel says you get equitable estoppel as to the non-concealment-based wrongdoing, but not as to the concealment itself. What Supreme Court did was conflate this doctrine with the issue of a breach of fiduciary duty claim that is duplicative of a breach of contract claim. That's a separate issue. That's not an issue on this appeal. ISG does not defend that reasoning. What they say is, as long as any one of the contractual breaches rests on concealment, you don't get equitable estoppel for any of the breaches, even those not based on the concealment. No case says that. It doesn't make any sense. I mean, think about the purposes of the doctrine, right? According to them, if you commit a wrong and then hide that wrong separately, then the plaintiff has the benefit of equitable estoppel. But if your hiding of the wrong is separately actionable, according to them, then you do get the benefit of your wrongdoing. That doesn't make any sense. Or perhaps their argument is we needed to plead 1,000 different breach of contract causes of action. That's not efficient, and no case requires that, right? And there's no case that says that you don't get equitable estoppel for anything as long as one of many of the breaches is concealment-based, right? In fact, what the cases say...
But isn't that based on the facts underlying the breach that the defendant is talking about?
I'm sorry, Your Honor, I'm not sure I follow the question.
Isn't it just the acts? You're saying there's a claim for breach of performing basic underwriting duties. So that's part of the facts that underlying your breach of contract, correct?
Right, and none of that has to do with concealment, right? We have failure to underwrite properly, failure to supervise third parties properly, failure to make sure the homeowner's warranty was effective. None of that is about concealment. So we're not saying equitable estoppel applies to the fact that they concealed their wrongdoing from us. That's separately a breach, but we're not saying equitable estoppel applies to that. We don't need to because it's independently timely, right? So what we are saying is that you apply equitable estoppel to the non-concealment-based misconduct. That's exactly what the Court of Appeals did in Simkuski. That's exactly what this court did in Gerzog v. Goldfarb. And so what the cases say is where the misconduct that is the basis of the claim is the same as the concealment or the same as the misrepresentation or fraud, that's when equitable estoppel does not apply. That's not the situation here. Now, as to continuing wrong, if your honors agree with us on equitable estoppel, then you don't need to reach continuing wrong. But as to that issue, should you reach it, the bottom line is that the cases describe the doctrine in different ways depending upon the nature of the wrong alleged. So, of course, if the wrong is a series of discrete wrongs, then you apply the statute of limitations to each one in a discrete way, which is what...
No, but I disagree with your analysis that it suspends the statute of limitations in some way. I think that any claim, I forget the May date, But any claim prior to the May date that was agreed to below, those claims are gone. And tell me why I'm wrong about that, or give me your best case on that.
May I respond, Your Honor? I think the best case for that is this court's decision in Palmieri. So Palmieri v. Wilkie Farr, that was the malpractice case where the law firm has client A and then represents client, on behalf of client B, pins the blame on client A. And the court says the statute of limitations is told until the date of the last wrongful act. Why? Because that's a continuous course of breaching conduct. The whole relationship is pervaded by impropriety. We've alleged enough to fit within that scenario, and so we think that the continuing wrong doctrine applies in that way.
All right, you'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, Sean O'Donnell with Herrick Feinstein on behalf of the respondent. I'm laughing because it's the first time I've ever argued with reading glasses, and I looked up and all I saw was a blur first. I apologize. Your Honor, as my colleague noted, there are two doctrines in front of the court. Both are well settled. One is the equitable estoppel doctrine, and the second is the continuing wrong doctrine. I can take them in whatever order the court prefers. Otherwise, I'm happy to start with the equitable estoppel doctrine. Okay.
Up to you, it's your
So
argument.
firstly, Judge Chan, to answer your question, the plaintiffs, according to their complaint, and that's at page 80 of the record, paragraph 72, beginning in July 2023, Amtrust repeatedly requested that it produce copies of documents. That's the underwriting files. And if you go back to the prior page in the record, page 79, you'll see that plaintiff alleges that notwithstanding the fact that they didn't seek documents until July of 2023, that they claim to have become aware of the massive losses and the inappropriate management of the program in 2022. And that's at paragraph 68.
Is that because it takes about 6, 7, 8 years before they know that something is wrong?
You're referring to the long tail that's
long tail.
discussed. That's right, Your Honor. So that's a perfect segue into really the start of how I think we should be thinking about the equitable estoppel doctrine. So it's a breach of contract case. And Your Honors know that the statute of limitations for breach of contract is 6 years. And there's no discovery rule in New York. So that the statute of limitations starts to run when the breach occurs, not when the plaintiff is injured or learns about the injury or learns about the breach. And Your Honor, the Court of Appeals in Ace Securities v. DB, it's cited in our brief. The site for that is 25 New York 3rd 581. Goes into detail about why that absence of a discovery rule from breach of contract claims is important. If you'll bear with me, it's a couple of sentences. I think it puts everything in context. It says, our statutes of limitation serve the same objectives of finality, certainty, and predictability that New York's contract law endorses. Statutes of limitation not only save litigants from defending stale claims, but also express a societal interest or public policy of giving repose to human affairs. And we've repeatedly rejected accrual dates which cannot be ascertained with any degree of certainty in favor of a blight line approach. The court then goes on to explain how that actually can result in some unfair outcomes at times.
I seriously don't think that you should be quoting that language in light of the position of your clients.
I don't understand your comment.
You don't understand?
No. Because there's a balancing of interests, Your Honor. So first of all, we have to give all of their allegations. We assume them to be true. We don't agree with their allegations, but for purposes of a statute of limitations analysis, we'll assume for them to be true. And what they're seeking for the court to do is to rewrite and impose a discovery rule in breach of contracts anytime that there's a fiduciary that's involved. So LLC agreement, limited partnership agreement, management agreement, brokerage agreement, the list goes on. And what the Court of Appeals, the highest court in New York, as you know, has said very clearly, pardon me.
Thank you
Your Honor, I'm not
for
trying to be-
enlightening me with that information. Go ahead.
What the court says is very clearly is why it is that we have a bright line rule, that there's a public policy decision in New York that you favor a bright line rule over something that could have vagaries and be subject to the subjectiveness of the discretion of various courts as to when a party learns of the injury. What the plaintiff seeks to do here is rely upon the equitable estoppel doctrine, which is, as all courts recognize, an extraordinary remedy. And for that extraordinary remedy to apply, there are two things that have to happen.
So, counsel, I just want to go to the issue of the home buyer's warranty and awareness of the injury. You
Yes.
just mentioned that awareness of the injury. So to the extent that there was concealment as alleged, was there a failure to engage in necessary due diligence? Were there red flags that were missed here, or was concealment really the name of the game?
So I think if we start to argue that there were red flags that were missed here, unless it's pled in the complaint, then we're not applying the right standard. We're going against the standard of review. They're entitled to the inferences. What we're saying is, and this is what I think Justice Crane was ruling her decision, is at the record, it's 286. The managing agreement imposes fiduciary obligations on everything that that ISG was supposed to do when they're performing the contract.
Did you answer my question?
Well, I don't.
Because
I'm unaware of red
I don't think.
flags. I'm sorry. I didn't mean to speak over
I'm
you.
asking because there was supposed to be home buyers' warranties obtained in order to limit the liability of the plaintiff. But where does due diligence come in with respect to equitable estoppel? Is there an obligation that was not performed or a responsibility that was not undertaken by the plaintiff in this regard? Because there were thousands of policies issued on the plaintiff's behalf, and allegedly, home buyers did not know that they had the ability to bring claims against the builders as opposed to the plaintiffs.
And the diligence that the plaintiffs allege that, or disclosure that we didn't do, is telling them every time we allegedly breached the contract. That's what they say. That's why Justice Crane points to the fiduciary obligations that are.
Was there an obligation to audit you on a regular basis?
They had the opportunity to audit us on a regular basis, and it's either pled or the documents show they actually did so several times a year.
Was there alleged concealment during those audits?
Not in the complaint, Your Honor. That is not alleged at all, that there was concealment. What the hiding, and this is really important, what they're relying upon is the fact that the ISG, the defendant, supposedly did not tell the appellant every time there was a breach that it happened. So if we violated the underwriting guidelines, or if we did something that issued a policy outside the parameters of the program, we were supposed to tell them right away. And they're saying that the failure of telling them that is what triggers the equitable estoppel doctrine. Your Honor, may I please finish answering the question? I see that my time is up.
You have 30 seconds to finish your answer.
Thank you, Your Honor. And so the problem with that is they're one and the same. It's what this court held in Noble, Kaufman, and TWU, which are all cited in our brief. You cannot use the equitable estoppel doctrine to stop the statute of limitations if the facts that you're complaining about are the same facts that are the substantive claims that you're pursuing. Here, the substantive claim they're pursuing is a breach of contract. The contract says you have to perform those obligations as a fiduciary, which they say requires every time that you breach, you're supposed to tell us about it. That's all the same act. What Noble tells you, Kaufman tells you, and TWU shows you is the failure to tell you that I breached the agreement. It's one and the same with the breach itself.
Thank you. You've said this already. Thank you.
Your Honor, and I didn't mean to offend the court
okay.
when I meant about the court.
Thank you.
Thank you.
Thank you, Your Honor. Just a few quick points.
Counsel, you want to pick up those two authorities? I think Transport Workers Union was a summary judgment motion. Obviously, this is a pleading motion. But Noble was on a motion to dismiss, right?
Right, but those cases, both Kaufman and Noble, and Kaufman I think might have been summary judgment too, although I'm not positive about that. There, the wrong was exactly the concealment or the fraud or the deception, right? There's still no answer from my friend about a case that says where you allege some breaches based on concealment or fraud and others that are not. Why should equitable estoppel mean? Why should it mean you don't get equitable estoppel for anything? Simkuski did the opposite right there. It applied equitable estoppel to the medical malpractice claim, but not to the fraud claim where the doctor lied about the injury, right? So he has no answer to that point in the case law. We're not seeking a discovery rule here, Your Honors. I'm well aware there's no discovery rule for breach of contract cases, but equitable estoppel is a well-established exception to the statute of limitations, including in contract cases. Nobody disputes that. The question of, they say that we knew there were losses and sought to terminate the program. So first of all, this goes to the Simkuski test, right? What's reasonable diligence? If the plaintiff does not file the action a reasonable time after the facts arising from creating the estoppel cease to be operational, then you're out of luck. What's a reasonable time? The statute of limitations period is a proxy for that, the Court of Appeals says in Simkuski. Well, we gave notice of termination of the program in 2019. That's within the SOL window. And by the way, knowledge of losses, knowledge that an insurance program is losing money, is not the same thing as knowledge that your agent is doing it badly or improperly or violating the contract. Insurance programs lose money all the time. It doesn't mean that there's wrongdoing. So we didn't know about the wrongdoing until much later. There's nothing in the complaint, Your Honor, about the audits, whether we did or did not take audits. That's been a subject of discovery. There's a lot of story there that I don't feel it's appropriate for me to get into on this record, but it's not in the complaint. Thank you very much.
Thank you. JN, an infant versus Strong. You may proceed.
Good afternoon, Your Honors. Arnold DeJoseph for the plaintiff appellant. In this medical malpractice case on a summary judgment motion, it's the plaintiff's position that the court below did not follow the rules regarding summary judgment. Number one, the court below said, well, you know, I don't think based on the evidence I hear here that it is necessary to give a warning about CVS post 10 weeks of gestation. And the reality is that's a factual finding, okay?
Well, it's a standard of care. It's a standard of care statement.
It's a standard of care statement, and she's finding the standard of care while she has what I will say is two conflicting expert affidavits.
Not any expert said that it was the standard of care to explain about the dangers of CVS to someone who's getting the procedure after 10 weeks. And here, the record shows that this was done at 12 weeks. So there was no reason to give.
That's not what the plaintiff's experts say.
Okay.
They literally go through it in their testimony and say,
Where does it say in the plaintiff's experts' disclosure that there's a risk of the things that happened here to someone receiving this test after 12 weeks?
1523 of the OBGYN's record, if you read, he goes through 4 reasons, number 4 being the explanation about gestation. And that goes...
And that's supported by what? Other than his opinion, it's supported by what? Because all of the literature does not support it.
It's supported by the CDC, the CDC and the statistical analysis.
We're talking about the 1995.
95 study, right.
But wouldn't that be somewhat outdated at this point in time?
Yeah.
Wouldn't it be superseded, for example, counsel, by the American College of Obstetrics and Gynecology, which disagreed and found that the risk really is before 10 weeks?
There's no debate that the risk is before 10 weeks. But here...
What literature states that the risk is significant in any way after 10 weeks?
The literature there's no literature. The only study that's cited on the plaintiff's behalf is the CDC.
The 30-year-old study.
That's correct. I mean,
right.
So
we know that in medicine continues to advance every year. So we don't have advancements of just a few years. We have advancements of 30 years. So you can continue, but that's not going to hold a day.
I'll see what it said.
You have time. I'm just, if that is what you are resting on, that 1995 study, when it has been contradicted by the defendant's experts and no response?
Judge, I'm resting on my experts' affidavits, but my experts' affidavits are based upon the 1995 study.
Right.
So it would seem that I'm caught in a vicious cycle, so to speak, right? So I will
Okay.
not earn any more wrath of the court.
There's no wrath. You have not, please don't say that. Please don't say that because, you know, I seem to be the world's favorite whipping board, okay? And I have spoken to you with utmost respect. I brought out a deficiency in the argument, and what I get back is, I'm gonna sit down because I don't wanna incur your wrath. Not at any point today, sir, did you get my wrath. Please be fair to the court.
I agree with you. What I was saying was I'm not going to sit here and argue the point that you've already told me is the court's not accepting. So why am I going to do that? That's what I meant.
Counsel, if I may, is there any updated literature that addresses the 1995 treatise on which, it's not a treatise, actually.
No, it's a
It's an
CDC
article,
study.
it's an article,
Yeah,
it's a weekly report.
there's a
Yeah.
weekly report that says it should be notified. but
It's the
but-
morbidity and mortality weekly report issued by the CDC back in 1995.
That's
So to the extent that it's a weekly report, did the CDC issue anything subsequent to validate or invalidate the findings that were there, which said, in essence, there is no greater risk to limb reduction greater than 11 weeks?
Not that I'm aware of in the record. Your
I beg
Honor.
your pardon?
Not that's in the record.
Okay. Thank you.
Right, thanks.
You may proceed.
Thank you, Your Honors. May it please the Court, Nicholas Tam from Shalbomny, Citron, and Spratt, on behalf of the defendant, respondent Mount Sinai Hospital. Mount Sinai established that CVS is a safe procedure that carries no greater risk of limb reduction deficits in a mother who's undergoing the test at 12 weeks. As this court fully ventilated, the 1995 CDC literature has been updated since then, and I can go through it very briefly. And they all indicate that there's no increased risk above the general population. Froster, 96, based upon a study of 138,000 patients. Of the 1,640 mothers who underwent CVS past 12 weeks, no limb reduction deficits were observed. Kuliev, 96, same thing. The CVS patients have approximately the same risk as the general population that did not undergo CVS. That's because when you stratify the data, and basically what that means is when you look at the data prior to 9 weeks and the data between 10 and 13 weeks, it's totally different. The reason why, Dr. Miller explained, is because the limbs and the structures of the fetus have already been developed. There is no increased risk. And the current ACOG guidelines
Dr.
actually...
Miller relied on ACOG, American College of Gynecologists, their guidelines and their literature, right?
That's correct. Dr.
And
Miller...
made the point about the MMWR article from 1995 that it had been superseded by those guidelines, right?
Superseded and also pointed out some differences between what was studied in the 95 CDC versus the more recent studies. One being that it didn't look at the literature or the studies after. Strike that. It didn't look at the risk of the procedure after 12 weeks. That data was not studied in the 95 study. And also it only dealt with limb digit defects, also known as transverse limb deficiency. They did see some digit defects prior to 10 weeks, but nothing with limbs. So that goes to causation.
Just returning to the informed consent form, which actually we haven't talked about very much, was it anticipated? It does appear to me that, looking at the consent form, that it was anticipated. There has been controversy regarding the risk of oromandibular and limb abnormalities when CVS is performed in pregnancies prior to 10 weeks gestation. However, evidence of this is limited, and the overwhelming experience suggests that the risk is extremely small. So it both sets out the 10-week cutoff point, and then also says even before 10 weeks, it's in dispute.
Extremely small, correct. And
So isn't that a sufficient informed consent?
yes,
I mean,
absolutely.
That's your argument, obviously.
Yes, absolutely. It does discuss that in general. It says the risk is extremely small prior to 10 weeks, but when you look at the way the fetus develops after 12 weeks and 4 days, the risk is not greater than the general population. So what this court needs to look at is at the reasonable person standard. The mother in this case specifically chose to undergo CVS because she previously underwent CVS. If you look at her deposition testimony, question, the pregnancy before...
Counsel, please don't read what I think you're going to read. I want to preserve this plaintiff's privacy. Okay, so I think you understand what I mean.
Yes.
Right? Okay.
Let me ask you a question then. Oh, may I?
Yeah.
With respect to what Ms. Rabinowitz, the genetics counselor, said, to wit, that there was some type of non-genetic insult that transpired since the earlier scan. I know that there's some argument on your behalf that she's not a doctor, but to what would you trace the non-genetic insult? Is it in the record?
The amniotic band syndrome that was mentioned repeatedly throughout the records, that was thought to be the mechanism for the
correlation?
Injury. Correct. The strands of amnion constrict certain limbs in the fetus, and that's what Dr. Ferrara testified to.
Thank
It may
you.
not be visible on imaging.
Thank you, counsel.
Thank you.
Thank you so much.
I will take my minute to talk about the
You got two, actually.
the proximate cause issue, because Dr. Ferrara did not give an etiology for what caused this. And specifically, when the child was born, the birth records say there's no amniotic band syndrome. It never showed up in a ultrasound, never showed up anywhere. And I submit to the court that it's kind of the hindsight creation of, well, if we have this CVS issue, this is what we're going to say. Amniotic band syndrome that never showed up in any ultrasound, okay? The same thing with the umbilical cord strangulation, which was another theory that was discussed.
Did any of your did any expert on your side say that ABS would show up in some type of diagnostic test?
Absolutely. That's the whole debate here about the proximate cause issue in this particular case, is that the birth record specifically said there's no amniotic band syndrome, and Dr. Ferrara is the one that said, well, it doesn't necessarily.
But here, the claim is a lack of informed consent, right?
Right.
So that the proximate cause has to be tied to that lack of informed consent.
That is correct. Okay?
And based on the records we have here.
And the only other thing I'll tell the court about the idea of that the fact that the mother had previously undergone the same procedure in an earlier pregnancy is that she was given the same exact consent form that she was given here. So there is no discussion anywhere.
Does that help you or hurt you?
I'm not saying whether it helps me or hurts me, but what I'm saying is it doesn't put her in a brighter light that she would have had any notification that there's still the potential, as the experts testified on her behalf in the motion, that there's a more significant risk of the limb loss in a CVS than if you waited 2.5 weeks here to do an amnio.
Thank you.
Thank you. Sorry, Judge.
No, sorry necessary. People v. Kenneth Ferguson. You may proceed.
May it please the court, Dinas Lokzau on behalf of Mr. Kenneth Ferguson. Double hearsay information at the suppression hearing did not establish probable cause for Mr. Ferguson's warrantless arrest, as it did not satisfy the basis of knowledge prong mandated by People v. Paris. The arresting officer had
You
no...
assert that Officer Pecora didn't have independent knowledge that the tickets were forged in your brief, but he did have an expertise in this area. You would concede that anyway, wouldn't you?
To the extent that he had experience in the theater district, yes, he developed some experience recognizing forged tickets, but he had absolutely no experience, concededly, in Central Park summer stage tickets. He also had never seen those types of tickets before,
And yet still, he was able to discern anomalies in the way that it was printed that raised suspicion to him about their authenticity, right?
Yes, Your Honor, but
So
that's...
you're not suggesting that an officer can only say, I think this is a forged instrument only if he's had experience with that exact kind of ticket before. That seems to be what you're arguing.
No, no, Your Honor. What we're arguing is that in this case, this particular officer took the additional step of calling the Central Park summer stage in order to confirm his, as Your Honor put it, suspicion. So he wasn't actually certain, or he didn't have the degree of knowledge he himself was satisfied with, and that's why presumably he made
So
that
at the
call.
time of arrest, right, what the police officers had was a complaining witness who told them that he bought tickets, he saw an ad in Craigslist for tickets to the Park concert, met with this man after speaking with him. The man sold him the tickets. He attempted to use the tickets, was refused entry with the tickets he purchased, and then he talks to the police do basically an undercover sting, right? Call him and get him to come back down. He again tries to do a sale of tickets, and he is arrested. And on his arrest, he has more fake tickets as well as other items, right?
Correct, Your Honor, yes.
Why isn't that enough for probable cause?
Well, the purchase, the buy and bust, so to speak, is not relevant for determining whether or not he had probable cause at the time of arrest. What is at stake?
Why not?
Because it's after the fact. The issue is whether or not he had probable cause when he initiated the buy and bust.
It was initiated on Craigslist, right? And isn't that a red flag just by itself? At Craigslist, you're not supposed to sell tickets on Craigslist.
Well, it might have been a red flag for the complainant who purchased the ticket.
And the police officer who knows that that's not an authorized dealership or venue for concert tickets in New York City.
Right, but that by itself was not sufficient for the officer. The officer made a call to the summer stage, relied on the
I
complainant's...
know you're focused on that, but what I am saying is that I could take that fact completely out of the equation and still find probable cause here. Why? Let's take the call to the park out of the equation. I agree with you. The way it's submitted, and God bless you, is hearsay, right? But let's take that out. I've got a complainant who says he bought a ticket from an unauthorized venue. He tries to use that ticket and cannot, right?
Yeah.
Why is that not enough?
Because those are the circumstances surrounding what we are arguing is the impermissible double hearsay. That the double hearsay...
I know, but again, the complainant going to the police station and saying, this is what happened to me, that's not hearsay, right? He is accounting for what occurred to him.
Yes.
And he can't, it's evidence he could testify at trial, right?
Certainly, but the summary of what he was told by security at the Central Park gate, I assume, that part is hearsay.
That
is
can't come in.
That
So if he says, I went to the park and I couldn't get in, not, they told me I can't come in, I could not go in with the ticket I bought.
Yeah.
Why is that not enough?
But I don't think that's what the officer at the suppression hearing recounts. What the officer at the
If
suppression...
I read it that way and this court reads it that way,
Then my only response would be that the hearsay cannot be divorced from the surrounding circumstances. Because the Court of Appeals has rejected the totality of circumstances analysis that the Supreme Court adopted after Aguilar-Spinelli, and said that the actual test is only whether or not to be focused on the hearsay, the double hearsay.
Okay.
I'm
You'll
happy.
have time on rebuttal. We have gone triple over your time. Mostly because of my questions, though. All right, go ahead.
Good afternoon, Your Honors, and may it please the Court. Robert Butlin for the people. To begin, Officer Pecora had independent probable cause to arrest defendant. So first, turning to his training, which, as Your Honors identified, was very relevant. It was exactly on point. He was trained in identifying documents and forged
Let's say I'm gonna push back, right? Let's say, no cigars, not the same kind of tickets. His experience doesn't transfer over because it's not the same. What else do you got?
I think what's important is that he was able to identify, as you said, several sorry, I'm not speaking right now.
Anomalies.
Thank you, Your Honor. So first of all, that they didn't have a clear-cut edge. Secondly, that they were flimsy. Third, that they were not neatly cut. Fourth, that they had barcodes tilted on one side. Then fifth, of course, he did say that they lacked professional appearance. That, of course, requires a belief that his training was directly on point. But even without that, I think all of those are pretty telling items in a ticket that if any of us had, we would be suspicious about it. And Justice Bolton,
what about your adversary's argument that these were Central Park concert tickets, not theater tickets? Ergo, there's a distinction, and can we really rely on the officer's past experience?
I think we can, Your Honor, for a couple reasons. First, he did.
But can you please, I asked you, what else is there, right? Because if anybody gets stuck on that, what else do you have?
Well, of course. So, Justice Gonzalez, I will turn back to your question. But there was also the buy and bust, or the sting operation, whatever you want to call it, which corroborated all of this story when he's able to get his hands on these tickets again. And Justice Gonzalez, a couple points about why we can still trust his opinion about the Central Park tickets. First of all, they're still tickets. There's no reason to doubt that they would be significantly different from theater tickets. He was trained in identifying traits in tickets that would be fake or real. There's no reason to believe that that was limited to just the theater area. And then he also, he was asked at one point, I believe on cross-examination, whether or not the tickets had seating on it. And although he couldn't remember, he was able to identify the fact that Central Park tickets don't typically have seats on them. So unless Your Honors have any further questions about...
How do you respond to the double hearsay claim?
Of course, Your Honor. So Justice Manzanet-Daniels, I think that was exactly right, that the victim's basis of knowledge was sort of the act itself of being denied entry to the concert. But even if Your Honors don't accept that reading, I think the double hearsay standard still is met by Aguilar-Spinelli here, because although we're not sure exactly who the security person at Central Park defendant spoke to, we know that the victim here was reliable. That's not even contested. And if his story is reliable, we can be reasonably assured that he spoke to someone at security. And if we get to that point, we have a circumstantial assurance of reliability by virtue of the nature of the job of security at Central Park. Of course, this is the person that denies or admits entry to the concert, and for that same reason, we also have it can be reasonably inferred the basis of knowledge of the security, that they can identify what is a real ticket and was a fake ticket. I think it all goes down to just the nature of security, because of course the victim was denied entry.
The victim didn't try to access the venue for the play. He went to go look at the seating. The security guard said, those tickets are not authentic. How is that not hearsay?
Justice Rosado, I think it's a close call, but I think what's important, two things are
I
important
don't
here.
think it's a close call. That's hearsay.
So assuming that is hearsay, Your Honors, so if that is hearsay, what's important is that it still meets the Aguilar-Spinelli standard, because we can reasonably infer the reliability and basis of knowledge of the security by virtue of the job. Of course, again, that's who denies or admits entry to the concerts. That's who you go to if you want to see a ticket is fake or real. But of course, we don't even need to go that far because of Pecora's independent probable cause. So
And the complainant did show the officer the ad
yes.
and the email exchange between
Yes.
themselves and the defendant.
And he gave a description of defendants who ended up matching that description at the sting operation. Thank you, Your Honors.
Thank you. You have a minute.
Thank you. A couple things. Wanted to bring your attention to the transcript, pages 11 and 12, where the officer says that he actually has received no official training on recognizing fake tickets. He also says it's his personal, I quote, opinion that these tickets were fake. So it's not that he has an expertise in this particular ticket. In fact, the other thing I wanted to point out, there's somewhat confusing testimony by the officer. First, he says that it's a regular printout. Then, moments later, on page 12, he says it's a regular ticket but did not have a clear-cut edge. So it's not entirely clear what it was exactly that struck his attention. It's also obvious that the complainant going to the venue did not recognize these tickets as fake. It was the assertion by security who said that the...
It was the denial of entry, right?
I don't know that the officer testified to that. What I recall from the transcript is the sentence, let me see exactly that, that the complainant was told they were fake by security at Central Park.
Didn't the complainant go to the precinct and say, I bought these tickets, I went to the park, they didn't let me go to the concert?
I don't know if he said that particular sentence, that last one.
The gist of it was he could not get in with the tickets he purchased from your client.
I think that's the inference, yes, presumably.
All right.
And just one last response.
You have 30 seconds.
It's to the assertion that it is not that it's reasonable to infer that security had the necessary knowledge to say that those tickets were fake. Actually, if you compare this case to the cases Campbell and Reed that this court decided, in those cases, there is a description of the factual basis for the conclusion that something was unlawful. In Campbell, it involved a management level employee.
All right, counsel,
And here we don't have any facts about the security.
Thank you so much. We will take a look at your papers again and your cases. State of New York versus Tyrone N. You may proceed.
Good afternoon, and may it please the court. Lorena Novotnik of Mental Hygiene Legal Service for the appellant Tyrone N. The court below erred in two respects. First, by refusing to grant Tyrone N's reasonable accommodation request to appear virtually for trial, thereby depriving him of his constitutional right to be present. And second, in its ultimate finding that Tyrone N is a dangerous sex offender requiring confinement. I'll turn first to the fact that the court should have granted the reasonable accommodation request. The undisputed facts here.
Reasonable accommodation request for what? What is it that he was seeking to be accommodated for?
Absolutely. So the uncontested facts that were in fact contained within the state's petition is that he has lung and heart problems. Those lung and heart problems.
Also, I thought that the reason for it, based on the record, was that he had had shoulder surgery.
Well, so that's the thing, actually.
Right?
There's two separate requests. So the initial request comes because he has these serious heart and lung conditions. And one of them, to be clear, is sarcoidosis of the lungs. He has growths on his lungs. And he has COPD. He has heart disease and mitral prolapse. I mean, these are serious medical conditions. So that's the first request. It's made in writing by email. Then he is present for 2 days of trial because the prison cannot reasonably effectuate the court's order here to do a very basic accommodation of a virtual appearance. So Tyrone N elects to come in person for 2 days of trial. Then the trial is discontinued, and in that meantime,
wasn't the defendant medically cleared to go forward with trial?
So it's a bit of a misnomer because
I'm sorry, what did you say?
It's a bit of a misnomer because
medically cleared?
Well, exactly, because medically cleared by who? So it was the state.
By the whatever medical authority he was seen by?
No,
No?
that's not in the record at all. So what we have here actually is as trial counsel, both for the state and for Tyrone N, understanding that he couldn't be produced for court. And so then the court calls and they say, well, I spoke to this employee, Gina, who who deals with production for court, and she said he's medically cleared. There's no evidence that he saw a
Is there
surgeon.
anything in the record that indicates that the defendant was not medically cleared and could not proceed to trial for medical reasons?
He had staples in his shoulder. His arm
No,
was
no,
in a
no,
sling.
no, 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 not staples in your
Staples
shoulder.
is not going to prevent someone from going to court, counsel.
Except that it was a 2-hour round trip each way. Would have
Counsel,
been
but that's
2
not
hours.
my question, is it? My question was there any documentation that this defendant could not proceed to trial for medical reasons?
No, but it's also important to recognize the timeline here. So when he makes the request for accommodation because of his shoulder surgery, that request was made on May 10th of 2023. The court gives him the option to either waive his appearance or appear in person on May 12th. And then the trial takes place from the
Counsel,
16th.
didn't he also, wasn't your client also offered an opportunity to ask for an adjournment?
Yes and no. So what the court says is we don't know when you're going to be able to see, a follow-up visit for a surgeon. So who knows when we're going to have to adjourn this to? And even if they had adjourned it,
But didn't she offer to adjourn it until he was better and could attend in person?
she offered to adjourn it until the shoulder issue had resolved. But the heart and lung conditions are not going to change. I think what's important here.
Counsel, is
So
that
counsel, you're
documented?
saying that any defendant who decides, I really don't feel like going to court, I have a medical, we have a lot of prisoners, a lot of defendants in detention with medical conditions of all sorts, some suffering from cancer in the middle of treatment for cancer, and yet they are still required to come to court or they waive their appearance. So a special rule should be made for your client?
No, and I would, for 2 reasons. One is that in the interim, the rules of the chief judge, Part 52, the court has promulgated rules here that don't recognize new law, but recognize the court's existing obligations of the law for ex parte requests for reasonable accommodation. And to the extent that we do have an aging and disabled population.
I'm troubled by the fact that there is no documentation that supports what you're saying. You're saying that the court failed to provide reasonable accommodations. And as my colleague, the justice presiding, just pointed out, what triggers that obligation? Is it simply the request?
So I can actually go through what the rules that have been promulgated state, which are, again, not new law, but clarify the court's existing obligations under the law. And that is first, a statement in writing that states the disability, the accommodation, and why the accommodation is needed. And that happened here at both stages. It happened at the initial request based on the heart and lung conditions. And it happened again after he had had shoulder surgery. So that triggers the court's responsibility then to look at the reasonable
To the
accommodation
extent that an
Was there
adjournment
anything-
was
I'm sorry.
offered, as my colleague pointed out, as Judge Rosado pointed out, to the extent that an accommodation was offered, in other words, an adjournment until the shoulder surgery resolved, where's the problem?
There's 2 problems. One is that he's in pretrial detention. So an adjournment prolongs the amount of time that he's
Been
in
in
confinement.
pretrial detention for years, right? I mean, this is not someone who had just been arrested. He has been in detention for a long time for some very serious sex offenses.
But to be-
So,
But to be clear, Your Honor, he's not detained on his existing charges. He's detained pre-trial for Article
we
10.
understand that.
So-
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the Court, Joshua Cohen for the State of New York. This Court should affirm the determinations that appellant suffers from a mental abnormality and requires treatment in a secure facility. Ample evidence supports both determinations here, where it's undisputed that appellant has pedophilia and antisocial traits, refuses to accept responsibility for his offenses, refuses to participate in sex
Also,
offender
can you respond to your friend's argument regarding the court not granting accommodations to the defendant? Do you see it that way?
I do not, Your Honor. Appellant was offered either a chance to waive his appearance, which he ended up electing, or an adjournment, and appellant never explained why an adjournment wouldn't suffice here.
I'm sorry to interrupt you, it's in my nature as a judge. Did anyone submit him or his counsel any documents to show the court that his heart issue was an issue and this is why he couldn't come in?
No, and that was never even given as a reason for the reason why he couldn't make the last 2 days of his trial, which were the only 2 days of the mental abnormality trial that he missed. The only reason he gave was the shoulder surgery, and he never explained why an adjournment until the court offered, and this was happening in May, and the court offered to adjourn till September. And the response that the court got wasn't, "I'm sorry, Your Honor, I don't know if that will be long enough for the appellant to heal." The response that the court got was, "He has made it very clear that he is not coming to court." And the court had in front of it a signed written waiver. Counsel didn't challenge the validity of the waiver before.
On that same date, May 16th, after the attorney makes it clear to the court he's not coming in any shape, way, or form, the court asks counsel, was she confirming that she was waiving respondent's appearance at trial? And counsel replied, "I'll leave it up to the court. If you would like me to move forward, I am prepared to move forward," correct?
Absolutely, Your Honor. And under this court's precedent, I'd point you to Your Honor, to the Lopez case that we cite in our brief. Saying something like, "It's up to Your Honor," does not preserve an issue for appellate review because that's acquiescing to the court's ruling. You can't say that a ruling is up to the court and then later complain about that court's ruling. And what the court was balancing was, on the one hand, we have this request for a virtual appearance, and there's no reason given why an adjournment would not suffice.
I have a question. On the 2 days that the defendant appeared for hearings, was there any need for breaks because of his heart and his lung condition?
That's not in the record, Your Honor. The only thing in the record regarding his health on those 2 days was that the court observed that he appeared to be in good health. And the court had to this was certainly not, this was within the court's discretion to decide whether to grant a virtual appearance here, because the court was balancing the difficulties and delays that the court had previously had securing his virtual appearance. The court didn't want to further delay the trial when the expert witnesses were there, ready to testify in person.
As to the expert witnesses, wasn't it the defendant's expert who was mentioned on May 16th, that the defendant's expert was flying to New York to appear as scheduled?
Yes, yes.
And it was defense counsel that said, "We're ready to move forward if you're ready."
That's correct, Your Honors. And also, MHLS, which is appellant's own counsel, had asked the court to move this case forward as expeditiously as possible. And all of these factors, the court took those circumstances into account when it made its decision, and it explained its ruling, and this is exactly why this type of thing is left to the discretion.
And to be clear, there wasn't a request for virtual, and as counsel indicated during her argument initially, twice there were serious technical difficulties at the prison, and proceedings could not go forward.
Yes, Your Honor. So the court balancing this made the correct decision to deny the virtual appearance, and given that there was a written waiver in front of it, proceeded with the trial. So appellant either did not preserve this issue for appellate review, or it was waived, and it was also forfeited because appellant had been warned that if he refused to go to trial, it would proceed without him, and his own counsel had warned him that the trial would likely go forward if he refused
Proceedings
to
on May
attend.
16th were followed the very next day, right? Followed up the very next day, May 17th, where the court again reviewed the question of whether a defendant was refusing to appear at trial or forfeiting his right to appear at trial.
That's correct, Your Honor. And the court explained its reasoning. The court made explicit findings that appellant had been notified and acknowledged his right to appear, but acknowledged that he could forfeit it without, if he didn't show up, and the witness was there ready to testify.
So can we move to the issue of civil management here as to the defendant?
Yes, absolutely, Your Honor. Ample evidence supported the decision that the finding that appellant is a dangerous sex offender requiring confinement, because in addition to the undisputed testimony that he has pedophilia and antisocial traits, he's refused to participate in sex offender treatment program.
How about his age? He's 70 years old. And according to, I guess, studies, the disorder, he would not be able to, or he would not be so inclined to recommit these sexual offenses?
I have a couple responses to that, Your Honor. So the age was a factor that the court considered, but the court decided that all of the other factors outweighed that, and that led to its determination. So the court accounted for age, and also there was expert testimony that appellant has all the characteristics of individuals who continue to offend into their 60s and beyond. He's a single individual serving long sentences for many sexual offenses against male victims. So that was accounted for. It is one factor that courts have to consider and balance, and the court considered it.
Male victims, it's male children, right?
Absolutely, Your Honor. And that
it's
leads...
it's at age 22, and where he's convicted of abusing 2 9-year-olds. He's 32, convicted of abusing 2 12-year-olds, and he's 42 when he's convicted of abusing two kids, 10 and 13 boys.
That's correct, Your Honor, and there's no indication that appellant's age would prevent him from abusing children. Again, these are not crimes committed against adults, they're crimes committed against vulnerable children.
Thank you.
Thank you, Your Honors. I respectfully ask the court to affirm.
Counsel, you have 2 minutes.
Thank you. I want to turn back to the question of the reasonable accommodation request for 2 reasons. One, I want to clarify what the request was based on his heart and lung disease. It was because of his increased risk for serious illness or death from COVID-19. So there were some studies done after COVID to suggest that people with sarcoidosis of lungs, one study, 7.7% of people who got COVID died of COVID. So what we have here is an extraordinary risk of serious illness and death from communicable diseases. The second piece is the idea that the prison just couldn't get it together. What we have here is perhaps the most basic accommodation request. It's a virtual appearance. I mean, this court, again, in the first year of the pandemic alone.
You're not suggesting because the technology exists that the court must grant this accommodation?
If it is reasonable, if and this is, again, it's a reasonable accommodation.
I'm saying, if the court finds there's no medical reason that your client cannot physically go to court, right, then it's really the discretion of the court whether the court wants to have a virtual proceeding.
No, Your Honor, because we have existing obligations under other statutes like the ADA or the Constitution, equal protection clauses. So what we have here—
But counsel, are we discussing something rhetorically? I mean, we have a record, and the record is devoid, am I right, of anything indicating that this person was not able to assist at trial, attend trial, because of medical reasons.
So I want to turn the court's attention to the People v. Krieg, which is a previous court's decision about the issue of a virtual accommodation. And the defendant in People v. Krieg also appeared for 2 days worth of trial before then saying this is too much of a risk to my health and I'm not going to appear. So the fact that it was possible to physically produce him is not the same thing as whether he needed a reasonable accommodation
But that wasn't
request.
before this the court below, the COPD and the lung cancer, and there were multiple technical difficulties making it virtually impossible to go virtually.
Well, let me just briefly, may I briefly respond? So if the prison had said, well, we don't have any wheelchairs today, I mean, it's the same sort of thing. We have a very basic—
No, wheelchairs and accessibility of internet in a cinder block building are not the same thing, right? Because if I don't have a wheelchair today, tomorrow I can get a wheelchair, right? But if there is a systemic problem in the building, I don't know what the problem was. But what we do know from this record is for 2 days they tried and they didn't get it, right? So the question is, how many times should the court not proceed with a proceeding that it must complete to do something the court doesn't think is necessary?
May I briefly respond? So if it is a systemic problem that they're not able to accommodate any virtual, I mean, is that not concerning? If they have an order to virtual produce and then they just
Counsel,
don't do it.
I know you're not asking us to consider that in terms of a global problem. We are focused here, just on this, what happened in this case. So we are not going to determine or write about whether, the prison system in New York State needs to get its internet together. That's a different issue, not before this court. You recognize that.
Except to the extent that it impacted my client's rights in this case.
I got it. I understand.
Thank you.
Okay. Nunes versus Turo.
Good afternoon. May it please the court, Allison Snyder for the defendant respondent. I'm happy to address any questions the court may have. If there are none, then we're happy to rest on our brief. Thank you very much.
Thank you. Metropolitan Property versus Pentair Residential. You may proceed, counsel.
Good afternoon, Your Honours. My name is Elizabeth Shaw. I'm here to introduce my colleague, Lazi Gebrundelson, and whose admission for his application for PROHAC HA admission was granted, and request your permission for him to appear today.
Okay, and where do you hail from, sir?
Me, I hail from Milwaukee, Wisconsin.
Okay, I have got family there. Welcome.
Not too far away. Beautiful city by the lake. But may it please the court, and thank you for giving me the opportunity to argue here today. Contrary to the way MetLife has framed its response to this appeal, because each theory of defect that they're arguing or that they're putting forth as a basis to recover against Pentair residential filtration have different elements of proof, each should be analyzed differently. I think for purposes of this argument, the manufacturing defect claim, so they're raising three different theories of defect: manufacturing defect, design defect, and they're raising failure to warn even though they never pled failure to warn or mentioned failure to warn in their discovery responses. I think the manufacturing defect claim and the failure to warn claim can be discussed briefly. There's no evidence at all of a manufacturing defect. I mean, at its core, that's a very simple claim. What are the specifications of the product? Does the product as manufactured comply with those specifications?
Counsel, say we agree with you. On the design defect claim, you got two of plaintiff's experts saying that the filter's failure was attributable to design failure, and then they do engage with your experts in their affidavits. Why doesn't that create an issue of triable fact?
So the issues we raise are that they haven't put forth a feasible alternative design, first of all, and
actually,
second,
they did.
I thought they did.
They actually pointed to another model
that we make.
Counsel, I'm still talking.
Sorry.
They pointed to another model produced by your client that has another design. So that's not accurate.
So I think it's helpful to step back and look at what these products are. There are a myriad of filter housings that house water filtration canisters on the market, including, as you say, different ones that we make. This one, and they all have different properties, they all have different levels of durability, they all have different designs. The one at issue in this case is clear. That's super important. It's the least durable design on the market, and it's represented to be the least durable design on the market. If you look at our representative's deposition and the manual, the clear sumps, as they're called in the trade, last half as long as the opaque sumps. The sump that plaintiff's expert Dr. Rios puts forward is an opaque sump. It's advertised by us, marketed by us, warned by us, that it's twice as durable. And these two issues dovetail, whether there actually is a feasible alternative, because I think if you're gonna look at a feasible alternative, you have to say, well, why did whoever put this filter in this application or this filter housing in this application, why did they choose this one?
Is it foreseeable that they would?
No, it's not. You would never choose a clear sump to put it up in a ceiling in a humidification system.
And
It's never
where
been
in your
serviced.
expert's affidavit is that explained?
In both Dave Eby's affidavit, he said that that it's not reasonably foreseeable to my client that.
Yes, but you just, see, my frustration right now is I'm hearing arguments from you that I don't remember reading in the expert affidavit, right? So, and look, I get it. It's hard to throw the whole kitchen sink into the affidavit, but you need to be able, especially where on the other side, they are addressing your experts' affidavits, then you've got to come back and explain why their conclusions are incorrect and the industry would say so hands down.
Well, I think the authoritative voice on this is Tom Clark's deposition. I mean,
because you say so?
No.
You understand, look, I've got two competing experts. So unless your expert gives me tap for tap every single opinion that they give me that controverts your theory must be addressed by your expert, or I have a battle of the experts that has to go to the jury.
Well, Tom Clark is the representative of the company. Their expert, Delano, is the only one who speaks to whether this is an intended or foreseeable use of this particular filter. He has no data, and you look at the small case, the case law requires he has no industry data, he has no testing, he has no evidence other than his say-so that it would be foreseeable to use the product in this particular application. Our sworn testimony of the company says we have never seen this application before.
How is that different from what the plaintiff is putting forward? We've got one side saying, oh, this is perfectly fine. The other side saying, I've never seen anyone use this.
Because
okay, so how is...
Because we're the ones that sell the products. We see how they're used.
Counsel, so now every time somebody gets sued on a product's design, if the person who produces it says it can't be that, that's it?
Well, I think, no.
Then we wouldn't have these lawsuits, would we?
Counsel, here's my dilemma. May I?
Yes.
On the one hand, you have an expert saying this is a filter for household use, as in a sink and so on, not for a humidifier in an HVAC, right? And versus someone who says, look at the PSI, look at the pounds per square inch. You've got a range, what is it, 25 to 125, I think? You've got a range, and here the usage was at 110. So arguably, because of the range and the fact that the use fell within that range, it works. It's not a problem. That's the dilemma that we have, and that's where the tribal issue of fact arises, because there is a gap.
Well, and I think, but that's just one criteria. And if you look at our expert's disclosure, our expert affidavit, there's more than just the range. Is this subject to fluctuations in temperature, high temperature? Is this subject to different cycles? And as a manufacturer, you can imagine we could never sell a product for an application that it's never been tested in, which is what their experts are trying to say. Even though you've never seen this application, there's no data on this application, we should accept that it was foreseeable.
Okay, thank you. You'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the Court. Nicole Jennings for the Plaintiff Respondent, Metropolitan Property and Casualty Insurance Company, as subrogate of Alex Kogan. This case presents a classic battle of the experts, a situation in which summary judgment is inappropriate. It is our position that defendant...
What evidence is there from your expert that it is a foreseeable use to take a product that is labeled for water filter, and then you attach it to the humidifier for an HVAC system?
Yes, Your Honor.
Which is on all the time, right? So that its use The way that you're using that machine is not what that machine was intended for. Why doesn't that throw you right out?
Sure. Well, our expert thinks that this was a plainly foreseeable use of the subject water filter. He points to the fact that this humidifier only ran on cold water, contrary to what defendants' experts are saying. And he also said that this the subject humidifier had very low cycling, so it wasn't constantly turning on and off, which created virtually identical conditions as if this subject water filter was installed under a sink. And then he also, of course, pointed to the PSI and how it was recorded at 125, or sorry,
Did he
110
explain
PSI.
how the mechanism of this machine operates exactly the same way to filter water as it does to filter a humidifier? Is that explained to us anywhere in these expert reports?
Your Honor, it's my understanding that Mr. Delano was of the opinion that the water filter was simply filtering the water before it entered the HVAC system, and we believe that's sufficient expert evidence to create an issue of triable fact and warrant that this motion.
That wasn't my question.
Sure.
But go ahead.
In Mr. Delano's affidavit, he does explain that the water filter was just filtering the water before it entered the humidification system. And
Right, but that wasn't my question.
Sure. Okay.
So, okay, go ahead.
But it's our position that defendant failed to meet its burden under CPLR 3212. Defendant relies on Preston versus Peter Luger to say that our expert opinions were not sufficient and that we didn't include empirical data and expert analysis, but
Also, you concede that your failure to warn claim is untimely, correct?
yes, Your Honor, and we do ask this court to consider it. In light of the fact that defendant raised an affirmative defense for the first time in its motion for summary judgment, we had no notice until its moving papers that they were going to argue that this subject filter was left outside of the insured's leak detection area, and they're blaming this leak detection system as one of the causes of this loss. Had plaintiff had noticed that this was going to be an affirmative defense, we would have certainly moved to amend the complaint to include a failure to warn claim, asserting that there should have been a warning with this water filter that it needed a leak detection system in the first place. So if the court does consider this
Also,
argument,
you failed to address it, correct? You didn't address this issue, correct?
in
The failure to warn claim, you didn't.
in the brief, are you meaning?
You're saying your conceding is untimely, but for us to consider it because they raised it as an affirmative defense. Is that your argument?
Yes, Your Honors. We don't believe that the defendant would be prejudiced here because they're the ones who raised the issue.
It would not be prejudice of a new theory of liability?
Well, Your Honor,
We
they're
have
experts.
thousands of cases that say the opposite, right?
I understand.
Okay.
Even so, there's an issue on causation here, and it's at summary judgment in a product liability action. When causation is disputed, summary judgment has to be denied unless there is only one plausible conclusion that can come from these facts. Here, defendants, experts say that the cause of this loss was due to over-tightening or poor maintenance, and our experts believe that there was a latent construction defect. And I want to point you to Speller versus...
Latent instruction defect?
Yes, Your Honors.
Is that another way of saying a warning?
There was a latent defect in the product.
I'm sorry, you're saying instruction or construction?
Construction.
Okay, I heard instruction, okay.
I'd like to point you to Speller versus Sears, where the Court of Appeals has made clear that a plaintiff can prove a defect circumstantially. So it need not point out a specific flaw. It's enough if the experts rule out all other potential causes that wouldn't have been attributable to the defendant, and that they conclude that the product did not perform as intended.
So to me, I find it interesting that you should make that particular argument, since this product was not intended for an HVAC humidifier, right? So how can they warn? How are they supposed to warn about a use that's not intended in the first place? Are they supposed to list every single thing you're not supposed to use something for? Or is a warning more like, this is what this product is for, and don't do this, don't, Don't put the cord next to the water, you know, don't put it in heat, in front of heat, that kind of thing,
Sure.
right?
Sure.
Not every potential crazy and uncrazy use of a product that could happen, right?
Yes.
Okay, all right. And you'll have time.
Thank you.
Thank you, counsel.
Very briefly, I just want to return to the alternative design theory that they put forward with this other filter sump. And going back to what I was arguing before, they've put forward a filter sump that is materially different than this one in that it's an opaque plastic, it's more durable. And going back to, you know, what these products are and that there are a myriad of products, this is not the design of a sump you would take and put up in a ceiling and not touch. There are metal sumps on the market. There are sumps that could last for decades. A plastic sump is meant to be a product that requires maintenance. You need to change the cartridges of the filter. This was not the appropriate design for this application, and the proposed alternative is a completely different product with different utility and different attributes.
I can't recall, can you remind me how long this, before it failed, how long had it been installed?
We think 4 years and some months. We
4
don't know
years?
exactly who installed it or why or who designed the HVAC system, but 4-something years is the best estimate.
Okay, thank you so much, have a great day.